we will start the session. We have already seen what is civil and common law system. In the United Arab Emirates, we have civil legal system based on the Egyptian and the French system. What is the civil law and what is the common law? Common law, you have two types of laws. The first set of laws enacted by the parliament. Also, the latest judgments issued by the Supreme Court, that will also the law in the common laws. Whereas in the civil law system, there is only code, civil codes, enacted by the respective federal governments. That will be the applicable laws. So that is the major difference, okay, between civil law and the common law. It is very important to know the difference, especially in the international arbitration. That is all about what we are going to learn. Therefore, when you are entering into an international contract, it is mandatory to know the jurisdiction of the other side, whether it is a civil law system or a common law system. After knowing only, you will be able to successfully protect your rights, successfully able to argue your points. Okay, so that is why it is important to know the difference between civil law and the common law system. Having said that, UAE, though it is a civil law system, civil legal country, it is having all the three types of legal system. It is having civil law in the mainland, and then federal law you have. Also, where the free zones are there, the parties, they have the liberty to choose civil or common law as per their choice. Okay. Now we will see quickly run through just to refresh your memory. What are the different dispute resolution systems we have before embarking on the actual arbitration? We all know negotiation that involves two parties without the interference of a third party to settle their differences. It is very, very informal system without any coercion or confrontation. Mediation, you have a neutral mediator who will facilitate the parties to explore the options in front of them. And here, this is the unique process where the decisions will be by the parties themselves, not by the mediator. It is a structured process where the settlement becomes legally binding. Having said that, it depends upon the jurisdiction where we are. Okay, in certain jurisdictions, it is not legally binding. But in certain jurisdictions, such as India, there is separate law, Mediation Act 2023. Therefore, the mediation decisions are legally binding and enforceable in the courts. Right. And then you have hybrid system, MEDAR. It is combination of mediation and arbitration. It is gaining popularity, especially in the construction dispute resolution. You all know that in any construction project, there will be n number of disputes in a particular project, which the parties, they can identify What are the simple and straightforward disputes? They can be delegated to the mediation process. Rest of the complicated disputes can be allocated for the arbitrator's adjudication. Okay. And the decisions of the mediator that can become part of the arbitration award as a form of consent award. And finally, we have arbitration. That is the core topic for our learning. So it is a formal, private, and binding process where the decision of the arbitrator is final and binding. Unlike the judicial process, litigation, we call it as litigation. The litigation, the outcome of the litigation is subject to the appeal, whereas the decision of the arbitrator, which is called arbitral award, is not subject to appeal, but subject to challenge. That also within a very limited grounds. Therefore, we say that arbitrator's decision is final and binding. Okay. Also, it is a unique process where the parties, they have autonomy. They have many choices to make, unlike the court process. Okay. Litigation, we have just seen. Litigation is an adversary process, and it is a long and tedious process. Of course, litigation and arbitration, they are inseparable, because even though arbitration is a non-court process, we need to approach court for various requirements even during the arbitration proceedings. Okay. Even after the arbitration is over, for enforcing our arbitration award, we need to approach the court. Whether you want to challenge the award or enforce the award, we need to approach the court. Okay. So in between, if you feel any difficulty in the form of audio or video, kindly, let me know. All right. So now let us know what is the evolution, history of international arbitration. You may think why we should know the history of arbitration. Because if you look at anything in isolation, then you may not know the objectives of the process. Okay. Any law, whether it is arbitration law or any law, if it is interpreted in isolation, that will defeat itself. So it should be interpreted considering its origin and the objective. What is the objective of the arbitration? We all know that arbitration main objective is impartiality, principle of natural justice. So to understand that, we must know the history, how it has evolved. Okay. To know, we have to travel back to the period of Alexander the Great. Okay. So it was very prominent in the Greek world of the 3rd century. When Alexander was ruling, he himself and his successors of the Eastern Mediterranean world, they very frequently recourse to this arbitration for terminating the quarrels. Okay. On several occasions, the monarch, the kings, they themselves acted as the arbitrators. And the modern arbitration, it was originated with the Jay Treaty in the year 1794. Okay. So this treaty was between Great Britain and the United States. When they occupied the United States, which established 3 arbitral committees to settle questions and claims arising out of the American Revolution. And then In 19th century, there were many ad hoc treaties. They were made. Significantly, Alabama claims arbitration under the Treaty of Washington in the year 1871. With that treaty, United States and Great Britain, they agreed to settle claims arising from the failure of UK to maintain its neutrality during the American Civil War. So that is how it has evolved. Okay. And then the Hague Convention, it evolved. So this is an important milestone in the history of international arbitration, Hague Convention. We all know that the International Court, it is located in the Hague, Netherlands. Okay. But interestingly, even before that, arbitration court was set up in the Hague. International arbitration, it was given a permanent basis by the Hague Conference in 1899. It adopted the Hague Convention. It stated that international arbitration for its object, the settlement of disputes between the countries by judges of their own choice and on the basis of respect for law. Okay. So subsequently, Permanent Court of Arbitration was set up. PCA, they call it as PCA. So this is where the disputes between the countries, they have been adjudicated. Even recently, there was an important adjudication between India and Pakistan regarding the Indus Water River dispute. That was arbitrated. Okay, it happened in the Permanent Court of Arbitration only. Okay, so that is how the international arbitration, it was formalized. Okay, and subsequently, after the establishment of PCA, then came the International Court of Justice, which we are seeing now. Once the International Court of Justice was set up, PCA, it went into oblivion. Okay. But again, it came back. Subsequently, there were some important treaties. Normally, for the international disputes, treaties are very important to resolve the disputes between the countries. Okay. So these are the important treaties. I'm just leaving it to you for your soft reading. Okay. And there are some geopolitical factors that also we must know, so that you will know how politically arbitration evolved internationally. Okay. After the end of the World War II, it was the emergence of many new and independent states, particularly in Africa and Asia. So once the countries have become independent, then the trade and commerce that flourished. Once the trade and commerce flourished, naturally the disputes also increased. Okay, and then it led to the globalization. Okay, so globalization, it is meant for increasing the trade opportunities. Again, it led to increased disputes among the countries and resulted in a mechanism, a demand for mechanism to settle the commercial disputes. And then came New York Convention. This is the cornerstone of the international arbitration. Okay, so this was started in 1958 when the New York Convention on the recognition and the enforcement of the foreign awards, it was concluded. Today, this is the cornerstone of international arbitration, to which over 168 countries are party to it. Okay, we have seen about New York Convention in our previous session. Anyway, we will come to know in detail, in the subsequent slides. Okay, then after 1960s, what happened? European Convention on the International Commercial Arbitration, it happened. And in 1965, regionally focused arbitration rules for international commercial arbitration, it was developed. Subsequently, UNCITRAL arbitration rules that came into force in the year 1976. Okay. Then 1966 ICST, ICSID. This is for the investment disputes between the states. Okay. And then finally 1980s UNCITRAL model law, it was born. So that is what stabilized or homogenized the international arbitration universally. Okay. And then after subsequent amendments, now we have the UNCITRAL model law, which is the basis for many arbitration laws in the respective countries. Okay. So this is about the evolution of the Arbitration Act internationally.